Kate, please join us here. Ms. Kate Ado, the Director of Public Affairs, Parliament of Ghana. We also have in the meeting the Ms. Sena Atu. Ms. Sena Atu is a very important person when it's come to private members bill in Ghana. Today, she's here in two caps to represent herself. And so I'll introduce her as such. When she gets here, we will hear from the horse's own mouth all the knowledge and wisdom that she has when the issue of private members bill comes up. So, Madam, you are welcome. Kindly join us here. And then we'll be joined online by Honorable Ras Mubarak. Honorable Ras Mubarak is a former member of Parliament and happens to be, fortunately, we say the first sponsor of a private members bill. So, in fact, when you go into the annals of the history of Parliament, when private members bill comes up, Honorable Ras Mubarak's name will be written in gold letters because he happens to be the first people. In fact, I envy him a lot. There are a lot of people who probably have passed through Parliament over the years, and their names, apart from being on the list of that particular tenure when they were in Parliament, that would be all. But for Honorable Ras Mubarak, so far as private members go, it's mentioned in the history of Ghana, his name will ever and forever comes up. So Honorable Ras Mubarak has joined us online. And the next person we've introduced already, that is Caroline Gator, Executive Director from Zelando Trust. And then we'll also be joined by Ray Ezabagbon, Resident Country Director, National Democratic Institute, the Gambia. Ray is also joining us virtually. So I will be moderating this section. My name, once again, is Gilbert Bokiti Boifio. So I'll now hand over to Ms. Kate Ado to give us the opening remarks. Madam Kate, your audience.
Thank you very much, Gilbert, for the opportunity. And thank you very much, PN Africa, for the opportunity for myself and Sena to be here. Sena was very careful about coming to talk about this particular topic because she didn't want to act ultra-virus her powers, but she's the most qualified person to talk about the private members bill, given the role that she's played, not just in that particular bill, the preparation and it coming to fruition, but also in the legislative drafting department of Parliament. So she's very qualified to talk about this afternoon's topic. And it's for that reason that I think that I do not have the competence to talk about it. But before I give very brief opening remarks on the matter, may I once again defend what, in my opinion, has become an erroneous impression about Parliament and its work. Parliament, and I have 5 minutes to do this and to do the opening remarks, so I'll be mindful of that. Parliament is no longer what it was in 2004 when I joined, or even 2015. We've come a long way. There are very, very significant strides that we've made in terms of engagement with citizens through CSOs and PMOs. Indeed, I find that now more than when I started with Parliament, that we have a lot more meaningful engagements, probably not as frequent as what used to happen probably in the 4th or 5th Parliament, but I feel like our engagements are now more meaningful, yielding very significant results, because Now people are not just accountable, but they're having to interact with their citizenry, because if you don't do that as a member of parliament, you will lose your seat. And parliament, in line with our open government policy, which we have taken very seriously. And that's one of the reasons why I regret not being here early when you spoke about the Open West Africa, because it's one of my things that I like to talk about nowadays. I feel like we've done a lot more in that regard. And the fact that we practice a hybrid system tend to make people, and I see someone shaking their head, but that's the truth, tend to make people hold parliamentarians accountable for things that they are not really responsible for. So you're talking about the provision of facilities and you are blaming the member of parliament, which really should not be their problem. In their representative roles, they are to articulate the needs and concerns of the citizens and to forward same and to seek resolutions to these concerns. However, to put the responsibility of the provision of same on members of parliament will be stretching it a bit. And that's why I think that there's serious conversation now about strict separation of powers and all the frills and advantages and disadvantages that come with it. So maybe it's time to have that conversation and see where it will lead us and whether that will put parliament in the light that it should put. And while parliament also is very appreciative of its engagement with civil society, and this speaker in particular is very keen on having a very rigorous engagement with civil society and PMBs, we also would like for us to be met sometimes half of the way, so that we can update information on how members behaved in the past and how they are behaving now, so that when we make submissions, these submissions will be considerate of what the real picture is now, as against probably what the picture was before, because sometimes we tend to use information that may not necessarily reflect what we have on the ground at the moment. So with that said, and I'm sure this will be conversation between me and Adams for the next few days. With that said, may I take the opportunity to say that Parliament obviously is very excited and proud of the private members' bills, which are now part of our legislation. And only on Sunday, the Right Honorable Speaker at a gathering mentioned the fact that citizens can now more actively participate in the legislative process. In the past, when we have requested for contributions to legislations by ways of memoranda and contributions, we haven't, even from civil society, had as much engagement as we would like to have. So you'd find that if a bill concerns a particular group of people, then those groups of people are likely to show up. So let's say you have a disability bill, then you have a few people with physical challenges showing up to contribute to that bill. But people who have expertise, who can actually influence legislation, and I'm talking about people like those of you gathered here, tend sometimes not to pay particular attention to that. And I think that is a blame that should be shared equally between parliaments and the people that we engage in those spaces. Because maybe we have found that maybe using traditional media or formal means shouldn't be the only ways that we try to reach all manner of people. And we're trying to change that so that we'll have a lot more significant, meaningful engagement with CSOs and PMBs when it comes to engaging PMOs, engaging in the participation of legislation. What the private members bill does, that's against the public members bill, which is usually parented by a member of parliament and is parented by a member of parliament on behalf of the executive. The difference now is that anybody and everybody can generate legislation by, engaging your member of parliament or any member of parliament, as Gilbert said. And we are also, we've put mechanisms in place where we assist with the drafting of the legislation. So we find that there are two very famous legislations that we are talking about, the LGBT one and one by, I think, Xavier Susu. Yes, those two are the ones that are now being talked about. But I do know that Professor Asari is also working on something. And there are a lot more legislations that are being worked on in the private members bill mechanism, which is making the legislative duties of Parliament more exciting. Now, our role in the Public Affairs Department and our role in bringing Parliament closer to the people is to implore people like you to engage with us more. There are a myriad of issues that will need attention. And so we think that legislation in those areas will help sanitize our society, will move our society in the direction that we want it to go. And it's for this reason that we think that the time has come for us to talk about things like private members' bills, for us to talk about things like policies, for us to talk about work that Parliament does, which in essence is work that is mandated by the people of Ghana for members and the institution to do. And so for my opening remarks, I think that what I'd like to leave with everybody is the fact that the time has come for us to participate more in the work of Parliament. Contributing to legislation is a very easy process. You can contribute when a bill is in the pipeline and is being worked on. You can contribute even when a bill is not on the table by giving unsolicited contributions, which some people already do. We are grateful for all of you, Star Ghana, PN Africa, CDD, by the Canadian Center, the Parliamentary Center for, and we were together just last week. Was it last week or this week that we were together? Yes, with the FMK and co. So we are hoping for a lot more interactions. I think that what we failed to do, which we are seeking to rectify, is a more rigorous, more constant engagement with CSOs and PMOs. So I'd like to thank you for the opportunity and to pray that we'll have closer ties, not just on this particular topic, but on other issues that affect our Parliament and the legislative process in Ghana as a whole. On that note, I'd like to thank you for your attention.
Thank you very much, Madam Keitado. And one thing that I like about, I affectionately call her Auntie Kate, is that she always take an advantage to, clear the air on something that pertains to Parliament before even going to address the main issues that she has been called to. She has been a very good spokesperson for Parliament, and we are privileged to have her, and we enjoy working with her over the years, and there are more work ahead of us to do together. So the next person to do the main presentation for us today is Sena Achu, and she is going to speak on the theme, Private Members Bill, the procedures and opportunities to engage. So I now hand over to Sena. Sena, your audience.
A very good afternoon to you all. It's obvious to me that you had a successful meeting earlier on, and I look forward to a successful one as far as this session is concerned. I'm most grateful to the organizers for this opportunity, and I'm here to give you my independent perspective as far as the issue of private members' bills is concerned. The theme, as I was told, 1 year of private members' bills in Ghana. I understand that it's intended to celebrate the 1 year or to celebrate the motion that was moved and adopted by the majority leader on the 16th of July, 2020. But I know you also agree with me that the issue of private members' bills far earlier than 2020. And Section 15 of the Parliament Act, which is 1965, as far back as 1965, Section 15 of the Parliament Act provided that subject to the provisions of the Act and of standing orders, a member may introduce a bill or propose a motion for debate in or may present a petition to Parliament, which shall be disposed of according to standing orders. So as far back as 1965, the legislative framework was in existence. And it's also worth mentioning that in 1998, when Justice V.C. R.A.C. Crabb was mandated to revise the laws of our country, he still retained that provision. So Article 93.2, as I know you are aware, vests in Parliament the legislative power. The 1990 Constitution, as I've mentioned, which vests in Parliament the legislative power, unfortunately does not specifically make reference to private members' bills. But there are several provisions which give credence to the idea that the concept of private members' bills was contemplated as far back as the time I have mentioned. If you look at Article 22.2, Article 93.2, Article 103, 106, especially clauses 7 to 10, and even Article 108, it's clear that the framers thought of private members' bills. In the case of Article 103, for example, the committees of Parliament are charged to make inquiries or investigate into activities and administration of ministries and departments. And such investigation and inquiry may extend to proposal for legislation. What it means is that it was expected that parliamentary committees should be able to initiate legislation or to make proposals for legislation to be initiated. I am also very mindful of Article 106, clauses 7 to 10, which provides for the framework where the president may choose not to assent to a bill. And it's interesting to know that in 106, where the framework is established, 106.12 specifically exempts Article 108 related bills. What it means is that if the bill is introduced on behalf of the president, and the purpose is to achieve the purposes mentioned in 108, the president does not have the right to say he will not assent. Invariably, it also means that if it is not introduced on behalf of the president, and it does not achieve any of the purposes stated in 108, the president could decide to assent or not, and the legislative process or the framework is clearly set out. Again, it is just to buttress the point that our Constitution contemplated private members' bills. The current standing orders, which was also adopted as far back as 2000, is replete with several provisions, which gives a member of parliament the power to introduce bills. Order 116, for example, requires that the explanatory memorandum should be signed by the minister or the member. That again shows that it was not contemplated that only ministers could introduce bills. Apart from the legislative framework, there's enough evidence in history to show that, again, the concept of private members' bills is not new. Justice D.F. Anand, for example, in 2000, bemoaned the inability of Parliament to initiate legislation within Parliament. And there are a lot of stories about the position of Speaker Ala Ajete. In fact, some of us took it upon ourselves to check the Hansards and to find out on what occasion he said that. We are yet to find that information. What we rather have is the fact that in 2003, he made statements in favor of private members' bills. As you are aware, in 2017, the Right Honorable Speaker Okwe, the Speaker at the time, promised to ensure that private members' bills is part of our history. And indeed, on 18 December 2020, he delivered on that promise. As of today, 5 bills have been gazetted. The Gazette publication of 9 July 2021 provides a list of bills that have been gazetted. This again is evidence of the fact that the current Speaker of Parliament is committed to private members' bills. And there are indications that, well, if I may just take a few minutes and list the bills that have been gazetted so far. 1, the Promotion of Proper Human Sexual Rights and Ghanaian Family Values Bill, the Criminal Offences Amendment Bill, the Constitution of the Republic of Ghana Amendment Bill, Office of the Special Prosecutor Amendment Bill, and Citizenship Amendment Bill. There are several bills that are currently being worked on. And the honorable member for Medina, for example, has indicated in the media, and of course initiated steps to establish modalities for the payment of compensation to citizens who are unlawfully arrested, restricted, detained, or acquitted on appeal, but who had previously served part or whole of the prison sentence. Again, some members have indicated or even tabled a motion for the enactment of PMBs to streamline corporate social responsibility in Ghana. One of the key issues that comes up for a draft person is a duty of confidentiality towards its clients, in this case, sponsors. So I have mentioned bills that the members have indicated to the public that they are working on, but I can assure you that there's a lot of work ongoing. Well, let me just mention 4 benefits of private members' bills. I can see I'm preaching to the converted, but let me just still go through. The private members' bills open the legislative process, as you have identified, to a wealth of ideas. And even though the legislative process with government-initiated bills, I want to take a quick minute and do the distinction. We have government-initiated bills and private members' bills. And then we have public bills and private bills. They are separate concepts. So if you look at the government-initiated bills as of today, the process makes room for stakeholder engagement, which again will solicit the input of experts, CSOs, academia, industry, private sector, and all of that. But as Kate has mentioned, the private members' bills now gives the stakeholder or gives the private sector or CSO the opportunity to initiate the policy and not to wait for the permission of the executive. Private members' bills also offer MPs the opportunity to respond to the needs of their constituents, where those needs require legislative attention. As Gilbert has mentioned, private members' bills offer MPs the opportunity to build career legacies. And it's also generally agreed that the process involved in the enactment of private members' bills deepen consensus building, because a sponsor is required to garner the support of his colleague MPs. I have always advised that one of the ways to increase a person's chance of getting a bill passed is to have bipartisan, and if it becomes irrelevant, multi-partisan sponsorship. All of that will increase their consensus building skills. Now, some people have asked, so why has the subject of private members' bill, why the drought for this year or for all these years? As you are aware, there are 2 main issues that have been raised. The difficulty that was raised with Article 108, and also the absence of a drafting office at the time. Indeed, the phenomenal motion that was moved and adopted on 6th of July is evidence of the fact that Parliament has abandoned the erroneous interpretation for Article 108. Now, as you are also aware, a drafting office has been established. So a member who intends to initiate a bill needs not worry about the language to adopt. Now let's go to the format that a private member's bill should take. Article 1062 is again clear. A private member's bill should be accompanied by an explanatory memorandum, and it should be gazetted at least 14 days before the date of its introduction in Parliament. Now, in the case of a bill which seeks to amend an entrenched provision of the Constitution, the requirement is quite different, and it's as follows: that before Parliament proceeds to consider the bill should be referred to the Council of State for its advice, and the Council of State is required to render its advice within 30 days after receipt of the bill. Subsequently, the bill should be introduced 6 months after it has been published, and Parliament is required, after the first reading, to submit the bill to a referendum to be held throughout the country, and at least 40% of persons entitled to vote should vote at the referendum, with at least 75% of persons who voted voting in favor of passing the bill. In the case of a non-entrenched provision, the bill is required to be published in the Gazette twice. The second publication should be made at least 3 months after the first. Subsequently, the bill should be introduced at least 10 days after the second publication. I wish to draw attention to Section 100 of the PFM Act, the Public Financial Management Act, which requires that any proposal or legislation laid before Parliament should be accompanied with a fiscal impact analysis. It's interesting to also mention that as of today, that has not been complied with, neither for the government-initiated legislation or private members' bills. So until Parliament probably decides to ensure that that provision is complied with, it is not a factor as of today. Now, when the bill has been introduced, then the usual parliamentary procedures follow. As you are aware, the first reading, the second reading, the consideration stage, and then the third reading. So I'm sure civil society is asking if they have ideas or they have a policy, where do they start from? My answer is that you should first get a sponsor and lobby a member who appreciates your policy, because Order 122 only empowers a member or a minister to introduce a bill. And so they have audience on the floor. So you need to lobby a member to appreciate the policy. And then you also need to get the legislative drafting office involved. The legislative drafting office, or the role of a draft person, is to translate policy into legislative language, taking into consideration the existing constitutional and legislative framework. So the legislative draft person is not responsible for the policy, or it's not responsible for initiating policy. However, the legislative draft person plays a critical role in improving the policy, or in assisting in developing the policy. So once your policy is clear, my advice is that you get the draft persons involved to help them appreciate your policy, and also to give them the opportunity to make the needed input. It's also my opinion that the time is right for the Law Reform Commission to probably be engaged more seriously, because I'm confident that they have several ideas that are sitting on shelves. And when you get them involved, some of these concerns or some of the observations that they have made can be initiated through the private members bill process. I'm not sure, I hope I've answered your questions, but seriously, when you have a policy, as I've said, you get the draft persons involved. There are proposals as to the internal processes that the draft person should follow. Because they are still proposals, I'm hesitant to discuss them with you because they are likely to change. That is why I mentioned that you get the draft persons involved. We appreciate your policy. There are several engagements that we have with you. Our usual work process is 1, understand the policy. 2, prepare a scheme. We don't need to bother you with that one. It falls squarely in the realm of the draft person. You do a legislative competence audit. That is again clearly in the realm of the draft person. We come up with drafts and then we liaise with you. We do a lot of back and forth. Most of in fact, all the bills that I have listed, which are stated in the 9th July Gazette publication, were several months of work. We do a lot of back and forth with them. When they are satisfied, it is submitted to the clerk. Let me quickly mention that when you get the draft persons involved, I've said one of the things that will also happen is that you write your proposal, or you do a formal request to the draft persons through the clerk, and then we take it up from there. Yeah, thank you.
Thank you very much, Senna, for that elaborate presentation. At least 2 things for me came out from your presentation. You've given us an idea as to the procedure, which is very, very important for us. And you've also indicated, not only you, but Ms. Kate also mentioned that the opportunity to engage, the opportunity for us to be part of the lawmaking process, which is very, very important. Now, we're going to move to Honorable Ras Mubarak. Honorable Ras Mubarak to share his experience. I mean, how he went about it, why he decided to even come up with the private members bill, and his was an amendment. So do we have Honorable Ras Mubarak? Okay, so perhaps whilst we are trying to get Honorable Ras Mubarak back, we can move to Caroline to share with us the Kenyan experience with private members bill. Kenya over the years have been practicing private members bill, so they have a lot of experience to share in that area. So Caroline.
Thank you. Thank you, Gilbert. Allow me to share my screen so that we do this quickly. So you're right that indeed Kenya has had a lot of experience with the private members bill, especially since the promulgation of the current constitution. But this wasn't always the case. Before 2010, as most of you might be aware, our constitution was mainly a parliamentary democracy, if you may, and the president had a lot of input into what went into parliament. But since 2010, the institutional and legal framework was altered, and we now have clear separation of powers with minimal control from the executive, from the president in terms of what goes into parliament. I won't belabor so much that element of Mzalendo Trust because I spoke about us in the earlier session about what we do. Our values there quite aligned with the work that you're doing as a PMO in terms of legislative openness and transparency. So allow me to just get straight on to the Kenya constitutional context. I hope you can see me, you can see that clearly. Sorry. Yeah, so the Constitution of Kenya 2010 established a presidential system of governance, as I have mentioned, and this is characterized by separation of powers amongst the three branches, the executive, the legislature, and the judiciary. And then we have a bicameral parliament with the National Assembly and the Senate. Our current membership of the National Assembly is at 350 and of the Senate is 68. So you can see that is inclusive of the respective speakers. So you can see quite a big parliament that we have. So, you know, like, the presenter just before me has really spoken about this process. How do you get a bill to parliament, and at what point do you facilitate public participation? So in Kenya, the parliament has the force and the necessary authority to create legislation. And that has happened through 4 processes. One is through a parliamentary party. Our constitution provides for the offices of the leader of majority and the leader of minority in each house. And the leader of majority represents the party with the majority and the minority vice versa. And that is in the 2 houses. So 2 majority leaders, 2 minority leaders. And they, on behalf of their political parties, can introduce legislation, of course, through the executive. Then we have the executive, which is introduced again through the leader of majority, through the same offices, and then the committees of the House, and the objective of today's meeting, the private members bill. Let me also mention something here at this point. So unlike other democracies centered on the Westminster Foundation, our members of parliament are not ministers, so they don't sit in cabinet. And that has really been a shift in how the executive presents its members, its bills, its legislative agenda to the House, because previously you'd have a minister representing the executive and pushing the legislative agenda, but under the current constitutional dispensation, that has to go through the party, and that's where the offices of the majority and minority leaders really play a critical role. Going back, so we have the individual members of the House who can introduce private members bill, And I also want to emphasize that distinction that the previous speaker made around the distinction between the private members bill and the private bill. So the private members bill is introduced in the name of the member sponsoring the bill, and that specific member can be on behalf of a civil society organization, an individual, an interest group, or even a corporation that wants to have their issues captured through a legislative proposal. Once this bill is introduced to the House through a sponsor, it goes through the same process. So it has to be introduced to the House through as a legislative proposal. And if the committee, the clerk is at the secretariat level, if they're happy with the legislative proposal, then the team, the secretariat team, goes ahead to draft the bill. And then it's taken for pre-publication scrutiny by the relevant committees. And if it meets the thresholds, it's then approved by the speaker for publication. Once approved for publication, it goes then to the government printer for printing. And then the main process, which is, first reading, second reading, committee stage, report stage, and then the third reading. But let me speak something here around the first reading, because I had the first speaker, I think Kate, speak a lot about public participation. So a very key tenet of the Constitution of Kenya is public participation. And so what happens is that at this stage, Parliament is mandated by the Constitution to make calls for public participation, and they do this either mainly through advertising in the local newspaper, but also through their website. And this is where institutions like Mzalendo comes in. So number one, we make sure that the public is aware of any bill that is due for public participation. But two, working with other civil society organizations and interested groups, we then organize, whether it's an online conversation or an offline conversation, we then organize for meetings to facilitate this public participation. So for example, if it's a bill on access to information, all the stakeholders that, whether from government, civil society, private sector that have an interest in that issue, we let them know that that bill is up for public participation, and so they can give their views. The second way we do that is through our legislative platform, Dokeza, which allows citizens, and which we shared with you at some point. I don't know why. So the Dokeza platform, which we shared with some of you in a separate forum, that allows people to generate memoranda and submit to Parliament. So finally, once the bill is passed through the third reading, it goes to the President for assent. And in some cases, he may disagree with some of the provisions of that bill and send it back to Parliament. But if there's no disagreement, then it is signed into law. Let me also mention here that the same process goes for the subnationals, our counties, in case the respective county governor will then sign the bill. Next is, what has been the success rate of the private members bill? As you're all aware, the private members bills are always, in most cases, used almost as the last option. So something has not either worked, the executive is not pushing a bill at the speed that is wanted, or somebody, an individual or a civil society organization has something that they need pushed, and therefore they identify a member, and then it's presented to Parliament. But if you look at this rate, this table, it shows the bills that has been presented in the National Assembly for the last 3 years. So you'll see in 2019, 13% of those bills were passed. In 2020, only 1.9%. 3 did not succeed. 36 of them, the private bills, were pending from 2019. And so this is a percentage of the total number of bills that were in the House that year, 2019. you'll see the number goes down in 2020, perhaps also impacted by the impact of COVID-19, because you'll also see that the number of bills in the House during the last year was low. As we speak now, in 2021, under the current session of the National Assembly, there's not been a single private member's bill passed or discussed, because none has failed. But we have 5 bills pending, which is about 15% of the 34 bills that have been presented as of Friday last week. Going to the Senate, again, you see the trend is the same, but in this case, it's quite lower. And here, this one, we go back to about 4 years. So 2017, only 1 bill, 2018, 3 of them, 2019, none, 2020, none. And you can see in the last 2 years, the number of private bills presented to the Senate has also been very low. And the percentage, again, even in 2018, where there was a higher, 11 bills and 10 of them failed, which meant that only very few were passed. So what has been the challenges? As you can see from the presentation, the success rate of private members' bill in Kenya, like in most other jurisdictions, is not very high. And part of that can be attributed to limited parliamentary time. So if you look at countries like Canada, and I think the UK, there's only 1 designated day for discussions of private bills. So I think either Canada or the UK has about 13 Fridays, in which about 65 hours in which private bills are discussed. In Kenya, private bills can only be considered on Wednesday morning. And sometimes that's also dependent on what other business is in the House. So even though they are earmarked for Wednesday mornings, they don't always take priority. And then also the prioritization, they seem to take a backseat compared to bills that emanate from the executive committee, or even political parties. Sometimes you have implementation challenges, especially where these budgetary implications. So those are some of the challenges. What are some of the opportunities that exist with private members' bill, and which, in my view, Ghana could borrow? It's an opportunity for the public, to be able to inform the government, the legislative agenda of the House, and especially in cases where the government shows some level of disinterest or is apathetic to some of the legislative concerns from the citizens. It means that as the public, whether through civil society organizations, you can organize and come up with legislative proposal, identify from Parliament someone you feel can champion your cause and help them in drafting that bill. And this is where now the technical support from organizations such as ours and yourselves that we spoke about, the sort of technical support that you provide Parliament, whether at secretariat level or members level, this is where now it really comes in, because as you are proposing this bill, you need to make sure that you have a team that is supporting the person you eventually identify as the sponsor of the bill, to be able to have all the information that they need, the resources they need, and the technical capacity they need to make a case for the bill. The second, of course, opportunity closely related to what I've said is about the fact that private members' bill present an opportunity to present the interest of stakeholders, such as corporations and individuals. And then finally, something I've seen here is that it can also act as a catalyst in cases where the government takes too long to introduce a bill and the public feels that it should be prioritized, and they proceed to develop a private members' bill. We've seen cases where then, because of that, the government then fast tracks the introduction of the executive bill. And we had a case here in Kenya, for example, with the children's bill, and some other bills that then it catalyzes. So even though the executive bill will then eventually take priority, the initial objective of having a law to address that specific challenge is finally met. So those are just some of the experiences from Kenya that I would wish to share. I'm happy to take any questions. Thank you. Thank you, Gilbert. I'm done. Did I lose you? I can't hear you. I lost you, Gilbert. Yeah, Gilbert, you're muted, so we can't hear you. You're on mute, Gilbert.
Yeah, Ben, Caroline, can you hear me now?
Yes, you are on mute. I can hear you, but I was just saying thank you very much and happy to take any questions. Thank you.
Oh, okay. So what we're going to do is that we'll take all the presentations, and then after that, we'll take the questions. So I am introducing the next speaker, who is a former member of parliament, and fortunately holds the title of being the first member of parliament to introduce a private members bill. So Honorable Ras Mubarak, you are welcome. And you can now share your experience with us.
Thank you very much indeed, Gilbert. And let me commend PN Africa, and the Parliament of the Republic of Ghana for organizing such a very exciting forum, to discuss private members bill, which is a key issue or a key tool to advancing our democracy. And I can't express how excited I feel to see Sena Achu, with whom, we spent quite a lot of time, going back and forth to get the first ever private members bill passed into law. I should be able to commend all previous speakers of parliament in the Fourth Republic for their tireless contributions to getting us this far, especially the former Speaker of Parliament, the Right Honourable Professor Michael Quay, because from the very onset, he had set the tone. I remember vividly his inaugural address to Parliament when he expressed how excited and how he was looking forward to ensuring that, members of Parliament would take advantage of private members' legislation. And true to his commitment to getting this done, it happened under his tenure. And, we can't mark and celebrate or observe, how far we have come without a special mention to him. But of course, also to Speaker Bagbin for the impetus he has, brought to the whole idea of a private members bill. Watching proceedings in Parliament from home, I see a lot of interest from members of Parliament, old and new. But you'd be surprised that when we started, there was no interest actually, but we kept plowing. A lot of members of Parliament, even to come on board to co-sponsor, the bill I had introduced was a problem. When we organized stakeholders meetings, we had to keep reminding members of Parliament of the need, to take full advantage of such an opportunity, But I'm really excited that it has opened the doors, for individual members of Parliament, for civil society organizations, for the donor community, for Ghanaians at large, to now go to their individual or respective members of Parliament and nudge them or remind them of things that they feel we could take care of through legislation. And the Road Traffic Amendment, Act that we had amended through private members legislation had come about as a result of a situation in my constituency where, a pregnant woman had lost a baby she was carrying, through a road traffic accident. There was little compensation for the unborn child, and when the matter was presented to me, I looked at existing legislation and I felt, as a representative of my people, we could do something about the existing legislation. And that's how come, we worked on the Road Traffic Act. But hither to that, I had started some work with Dr. Rashid Dramani's Africa Center for Parliamentary Affairs. When Speaker Okwe gave the tone for us to do private members bill, the first thing I wanted to do was legislation on campaign financing. We had started some work on the quiet with Dr. Rashid Dramani, had engaged Star Ghana as well to get it off the ground. But we realized it was going to be a very contentious issue in Parliament, and that we wouldn't get the kind of bipartisanship that Senna, that Caroline, and other speakers had spoken about. Because if you're doing a private members bill, you want to make sure that it goes through. What's the use in starting something that you can't finish? But even though party campaign financing, which is a key thing which undermines our governance, would be something we would have to legislate on eventually. It will be exciting if that is taken care of by government bill. If not, I would encourage current, members of parliament to take an interest in that, as it is something that is affecting our democracy. And there are a raft of issues that one can look at in proposing legislation, from archaeology to zoology. The most important thing is to be tenacious, because Senna, if she were to share her experiences, would tell you that it wasn't a walk in the park. It wasn't a walk in the park. It wasn't an easy road at all. I mean, there were moments that we felt like, look, I just don't want to have anything to do with this. I mean, what the heck? This is something you're doing for the country, but you want traction on what you are doing. You want it to move at a rate that you feel would be commensurate with the challenges that is existing at that particular moment. Unfortunately, Parliament has so many issues to deal with that. If it's not getting traction, if it's not getting the needed attention, you can't necessarily blame the system. However, looking forward, there are things that we can do. There are experiences from other parliaments that we could glean on, to improve on how we are dealing with private members legislation in the Parliament of Ghana. If you look at the UK, for instance, Caroline touched on it briefly. They've got the 13th Friday. So in every session of Parliament, the 13th Friday of that session is dedicated exclusively to private members' bills, or exclusively to, backbench bills, where private members' bill, gets priority over any other activity. We had attempted to set a day aside when we were amending the standing orders of the Parliament of the Republic of Ghana. Unfortunately, I don't know if it has been passed yet, but it was one of the things we felt we could do to give true meaning to the concept of private members legislation. Because you want a situation where it would not be relegated to the dustbins of whatever activities coming to Parliament. You want a situation where it would equally be given priority as government bills or legislation. And to be able to do that, you need to deliberately set aside a day and time to give members of Parliament, private members of Parliament, an opportunity, to deliberate on the legislation that they are proposing. I have also seen subsequently from our Parliament, for instance, if you look at the one on LGBTQI+, I've seen the Honorable Reverend Intim Fodjo's name as part of the sponsors. I probably would have to get some explanations from Senna and others. I find it very, very strange. because the Honorable Member of Parliament, who is a co-sponsor of that legislation, is a member of the executive. He's a Deputy Minister of Education, I think. And so the whole concept of private members bill is to have persons who do not belong to the executive, to push legislation. Now, once you have members of the executive taking part in private members legislation, it defeats the whole process. I mean, you can look at examples from anywhere in the world. I have not seen any example of any country where ministers or deputies sponsor legislation. So that is something that the Parliament of the Republic of Ghana would have to pay attention to and probably discourage going into the future government ministers or deputies taking part in private members legislation. But I can understand the Honorable Reverend is very passionate about the topic, and I can understand why he had put his name forward as a sponsor, but it defeats the purpose of private members legislation. Now, there's another challenge that I think we would have to also look at: the prospect of filibustering. This has happened elsewhere in Parliament, in the United States of America, at the Senate level, in Congress, in the UK Parliament, Canadian Parliament, where other members of Parliament have used the opportunity of filibustering to frustrate private members' legislation. And if you look at Canada, for instance, they've done private members bill for more than 100 years, I think. But if you look at the number of legislation that have been passed over a 100-year period of allowing private members legislation, it is not commensurate with that time. So going forward, we probably in our standing orders would have to put in place safeguards to ensure that members who are not excited about a particular legislation would not frustrate that legislation using the channel of filibustering. But on the whole, this is a very good thing for Ghana. And I would encourage the public. I've seen, young people join the discussion, on Zoom, which is very exciting. We would encourage anyone listening, watching, who may feel that some legislations in our book are redundant and has some suggestions to actually take advantage of this novel thing that the Parliament of the Republic of Ghana is doing. Finally, and I see Kate Adu as well. Kate, my disappointment stems from the fact that as important as this is, you are not streaming this on the Parliament of Ghana Facebook page, which could have given a lot of people, access to such an exciting, discussion that we are having. Hearing the experiences from Kenya, my sentiment, hearing Sena's views on the processes, I think it has to be as far-reaching as possible. And in the future, if programs like this are organized, currently Parliament is on recess, so it wouldn't really hurt, to have a program like this stream live on Parliament's Facebook page that could reach as many listeners and viewers as possible around the world. So I thank you very much. I wish us a wonderful observation, and I look forward to seeing a lot of private members' legislation passed in our Parliament. Thank you very much for the opportunity.
Thank you very much. Thank you very much, Honorable Ras Mubarak. Can those online hear me? Honorable Ras Mubarak, can you hear me?
Yes, Gilbert, I can hear you loud and clear.
Oh, okay, thank you very much for your presentation. And I notice Kate has taken notice of one or two things. Same with Sena, so they will respond accordingly after we've taken the presentation of Ray So Ray is going to give us the international experience on the successes when it comes to the implementation of private members bill. So Ray, we'll now hand over to you. Can our technician check whether Ray is online?
Can you hear me?
Yes, Ray, we can hear you.
Great. All right. Good afternoon, everyone.
Good afternoon, Ray.
It's really my pleasure to be part of this conversation. So first and foremost, I want to thank the organizers of this discussion, PN Africa, for bringing everyone together to discuss issues around democracy and good governance. I have listened to the previous speakers, and I must say that they've already laid out a very strong foundation for this discussion. I cannot agree less on the issue that they've raised, the points that they've already discussed, the Kenyan example, the Ghana example, the progress that have been made in Ghana, the legal framework, and all of that. So those are very rich background information. For me, having worked with Parliament over the years, interfacing with them directly and supporting them to draft bills in the course of my engagement with parliamentarians at the National Assembly level. So particularly in Nigeria, and also what I have seen in other countries like Kenya. I was in Kenya as well to see how the budget process evolves in that country, Uganda, and among others. So my first impression is that the challenges we are having in many of these countries about the success rate of private members bill is not peculiar to one particular country. We know, for example, that when we talk about private members bill, the first impression that comes to mind is that this is a concept that is situated within the context of the Westminster parliamentary model, which most of the Commonwealth countries have adopted. And of course, we know that in Ghana, Ghana has a very unique system where you have the president at the top, and then the National Assembly is a hybrid. A hybrid in the sense that you have members who are members of cabinet and also members who are elected independently who are not members of the cabinet. So that is very an interesting scenario there. So now the question is, in Ghana currently, and in many other countries, whether or not members of parliament, private members are able to scale through the legislative means is a function of several factors. It's a function of the legal environment, the legal architecture. It's also a function of the history of the country, the historical context, the norms, the legislative procedures over time. So it's a combination of all of these factors. So that what you find in Australia or what you find in Canada, the challenges that the MPs may face there may not be exactly what the MPs in Africa or in Ghana, as a case study, could face because of the different contexts, different historical contexts, and different legal environment. So it is interesting to hear from the first speaker when she laid out the fact that the framework for private member bill in Ghana started way back in time. I think she mentioned the Parliamentary Act the articles in the Constitution, the standing orders, and all of that. So now, the question is, if we have to look at countries that operate under the Westminster parliamentary model, the UK, the Canada, Australia, and the rest, Ghana in that mix. Then we vis-a-vis what operate in a presidential democracy, in context where you have separation of power between the three arms of government, countries like Nigeria and several other, the US and the rest. So you'll find that the experiences are not exactly the same. In the typical Westminster model, you'll find that where you have members of parliament, the majority members of parliament that are drawn from the executive branch, the issue is that the parliament in those countries are structured to pass bills that reflect the legislative agenda of the government in power. So that is how it is structured. And in most cases, that is why you find that in most cases, perhaps over 80% of the bills that come on the floor of the parliament are coming from the executive branch. The executive set the agenda, they have the policy agenda, the policy framework of government. The legislative agenda is structured to address those issues. So invariably, private members' bills suffer in those kind of setting. But that is not to say that there are no opportunities for private member bills to be considered. The international standard, by parliamentary protocol, every legislature, which is a democratic institution, operates to aggregate the views of every member of parliament, both those in majority and those in minority. Why the rule is that the minority may have their say, but invariably the majority will have their way. That is a common parliamentary norm globally. So, but international standard gives strong protection to the views, to the perspectives, and to the rights of the minority. So looking at it from this context, even if you have a government that is dominating the executive and also dominating the legislature, it doesn't follow that members who are in opposition or members who are minority should not have a say in the affairs of governance, or should not have the capacity to generate legislative ideas and proposals on issues that borders on public policy and common the welfare of the country. So they have those rights, and those rights are typically protected internationally. Now, I have heard that some of the progress that have been made in Ghana over time, it looks like the challenges that they've had in that country over time have been addressed. Opportunities to collaborate have been identified. And it appears that there is a heightened expectation from members of the public that they want to see more private members be. But again, it's not a rocket science whether or not a bill that is sponsored by government entities and those sponsored by private members in parliament, whether or not those bills will succeed, is a function of several factors. So what I have come to realize is that from experience, I have seen that even in typical presidential democracy, where you have clear lines of demarcation between the executive and the legislature, there are some government bills that hardly see the light of day. So now the question I would prefer to dwell on those opportunities, the challenges, and then what can we say are the way forward? Because in many countries, like the last honorable said, the Canada that has a history of over 100 years in a private member bill, they are still struggling. Australia, we have seen the success story in Australia where private member bills were passed into law that require compulsory voting in federal elections, for example. Landmark, very, very landmark. And for some of you who are also following what is happening in our sub-region, just yesterday, the president of Nigeria signed the petroleum industry bill. And if you look at the history of that struggle, among many others, the Niger Delta bill, for those who understand what is happening in Nigeria, the Niger Delta community, those are private member bills, and many other examples. So the question is, why do bills succeed and why are some failing? I think we should be looking at those factors. For Ghana, where now that we know that the legal framework is there, the parliamentary framework is there, so they have all the instruments that would enable them, the members, to be inspired to work more on members' bill for those bills to succeed. Now, let's look at some of the challenges that we have seen. In issue of time factor. In the typical Westminster model, you find that only a special period is dedicated to private member bills. And even those periods, you are not even sure that those bills are going to be discussed. Other issues like public petition, urgent questions, point of order, government statement, all of those ones could come up, and those bills private bills could be overshadowed. Then we also have to talk about issue of lack of technical and research capacity on the part of the members of parliament. You see that unlike the executive branch that deploys its bureaucracy, the entire bureaucracy, to conduct research and draft technical bills, most members of parliament do not have the skills to draft pieces of legislation. So these are issues that need to be addressed. Then again, you find that most members of parliament do not even have very strong advocacy capacity to push through some of their legislative proposals. So in terms of trying to find out what will be the opportunities going forward and what we can do to enhance the capacity of members of parliament to generate private member bills and to push them to their logical conclusion, I have outlined a few recommendations. The first one is that private members of parliament should develop very strong capacity in policy and research to enhance their ability to generate legislative proposals. That is very key. So if they do that and they see that their legislative proposals align with the overall legislative agenda of the parliament, chances are that they could say through, whether or not it's sponsored by government. The second one is, I would want to also join the previous speaker to recommend that the members of parliament should foster more collaboration with civil society organizations to benefit from their expertise on thematic areas and in setting legislative agendas that support private member bills. That is very key. We know the limit of their capacity, people with different background. So they need to work more, build more alliances, identify allies and targets that will help them to push through their agendas. Then thirdly, members of parliament are urged to develop stronger legislative advocacy capacity to enhance their capacity to build consensus around subject matters and push through legislative proposals. This is very key. So the fact that you have a very beautiful idea doesn't mean that once it comes on the floor, the parliament is going to be passed into law. It's not served that way. So they have to really work very hard and then build alliances and then build consensus around those issues. Chances are that those bills could just stay through. Then members of parliament are also urged to build stronger media and stakeholder support base for their legislative proposals. The point is that it is not the case that all bills must be passed into law. I think there is we need to disabuse people's mind about that. It is not the case that all bills may be passed into law. Some bills may be introduced to generate public discussion around a particular subject matter, around a particular problem, to gain government attention. And in most cases, in some cases, we have seen that government will wake up and say, okay, this issue, let us address it. And once those issues are addressed, of course, the purpose for that bill, in my opinion, has been achieved. But how do you throw throw light on those issues? How do you, engage people, engage the media and other stakeholders to have support for those proposals is very critical. And lastly, I also urge members of parliament to develop very strong communication strategies using different approaches, to draw public attention to issues that are dear to them. In this era of digital era, where we can use social media and many other approaches, but it's very important that members of parliament should, utilize these different areas of opportunities they have to, to engage public on issues that they are driving. I think we should be looking more in this area. I don't think the constraints are really so much about whether or not you are a private member as opposed to a government bill. The citizens of every country want to see progressive ideas. Whoever is bringing those progressive ideas that is supported with data, a research that is supported with data that is very credible, that is intended to solve a problem that affects the larger portion of this community. Why would those proposals not receive support from other members who are even on the government side? So I think we should be looking more in this direction. But overall, there is no clear-cut solution as to whether you're in Ghana as opposed to somebody who is in US, if you're a private member, whether your bill will succeed or not. But it requires a combination of some of those factors I mentioned earlier. The historical context may be different. The legal context may be different. The legislative norms, nuances, and all of that may be different. So we need to balance all of this. The political system in the country may also be different. How you engage the parties and all of that. So these are the issues that we should consider. And I think that will give us a very strong basis to support PMBs, not only in Ghana, but in this sub-region. So maybe I should end there. In case if there are other questions, we can take it during the Q&A session. Thank you so much.
Thank you. Thank you too, Ray. The technicians, can they hear me online? Okay. Thank you very much, Ray, for that elaborate presentation. So before I hand over to the audience, both in the room and online, if there are any questions, I have two questions that I quickly want to ask Senna, and one for both Ray and Caroline. So Senna, I want to find out from you, is there any cost involved in bringing a private member's bill? Involved. And then the second question that I want to ask you is that in the course of Parliament working on the private members bill, let's say at a committee level, can the sponsor of the bill say that I'm not interested anymore, so I want to abandon it? Like we know governments can withdraw a particular bill for one or the other. Does the same opportunity hold for a bill that comes under private members bill?
Thank you. In the case of cost, the cost is more about the cost involved in lobbying, but there's no cost as far as engaging the legislative drafting office is concerned. If I share experiences with the various bills that we've worked on, sometimes the nature of the policy will determine how many stakeholder engagement you should do. So in the case of Honorable Rasmuba, for example, we didn't have to do too much stakeholder engagement. Unlike the issue of confidentiality, well, if I mention the proper human sexual rights, that one involved a lot of stakeholder engagement. And they had strong support from the civil society organizations and the other people they were working with. That also made work not too burdensome for the draft persons. Because the nature of our work is such that we look at the policy, we raise several questions. And our expectation is that those questions are specifically answered so that we make progress. But if they don't have the strong technical support, the MP is busy. He needs somebody who will sit down and answer each of those questions. And so in some cases, I've had that difficulty with MPs because they have a dream. They discuss that with you, but the nitty-gritties, you don't get a chance to meet them and all of that. So that support probably will cost an MP. But engaging the draft person who is an employee of the parliament, who is part of the parliamentary service, it doesn't cost. Yes, and if your policy is so clear, you don't have to do too much stakeholder engagement. Yeah. I also want to mention that we've had cases where some bills are actually were initiated by petitions that were submitted to the speaker. So that is also an option to consider. Then on the issue of withdrawal, just like the bills, and as I keep on mentioning the 16th July motion, it was also determined that the procedure that applies to government-initiated legislation should apply to the private members' bills. So just as how the executive has the right under the standing orders to withdraw their bills, a private member also has that. There were discussions to the effect that because when it is introduced, it becomes property of Parliament, there should be some explanation or Parliament should have the right to refuse, but generally it was abandoned. It was agreed that the procedure as applies to government-initiated legislation should apply to the private members' bills.
Thank you very much. Yes, okay, yes.
So on the issue of sponsorship, why in the proper human sexual right, for example, we have a minister. My opinion is that a private member's bill is just a bill introduced by a member of parliament in his or her capacity as a member of parliament. It is not being introduced on behalf of the executive. Because if we all agree that one of the opportunities that the PMB offers is that a member of parliament can also have the needs of his constituents addressed, if those needs require legislative attention, then it will not be fair to say the member of parliament who is part of the executive shouldn't initiate private members' bills. Like you all know, we are still at the formative stage of what we want our private members' bills as a country to look like. So these are still discussions, but my opinion is that a minister should not be debarred from initiating legislation. The critical thing is that he's not doing that on behalf of the executive. Yeah.
Okay, thank you very much.
If I may, Gilbert.
Yeah.
Just a quick one. So on cost, yes, indeed, it may come with some costs because for some of the stakeholder engagements that we held, in respect of the bill that we passed, some of the meetings were held in Parliament House. But imagine instances where you would have to go outside of the precincts of Parliament because there are other pre-arranged committee meetings and sittings, so that definitely would come with some cost, and we should have that at the back of our minds. And Parliament should, make funds readily available for many of those meetings. In the one I did, for instance, there are instances when would have to get Senna and a few others to go and buy water, from my pocket or from her pocket, but that is why it is important to also get, CSOs involved in the process so that if it requires spending some money to get it done, these sponsors can lend a hand. Finally, on the point about government, ministers taking part, not to belabor the point, but I completely, disagree with Senna. If you look at what private members' bills are all over the world, there are bills introduced by members of parliament who are not ministers, You can check with Westminster, the UK House of Commons or the Lords, where we have drawn a lot of our practices and procedures from. Unless, of course, like she said, we want something that is akin to Ghana, which is hybrid. That could be understood. But having ministers take part in private members' legislation defeats the purpose for which it were made available.
Okay, thank you very much, Honorable Ras Mubarak. I can see that the audience are eager to join. So just my last question, then the audience can have the floor. So for Caroline and Ray, I just want to find out, over the years, with your observation of the admission of private members bill, both in Kenya and Nigeria, Sierra Leone, and other places, is there the opportunity for the process to be abused, to get lobbies deciding to, use that particular process to their benefit? Caroline and Ray, if you can quickly answer that, and then I will yield the floor to the audience in the room. Do you have Caroline and Ray?
Okay. Are you there?
Yes, Ray, you can go on.
Okay. Well, whether the process could be abused, first and foremost, the possibility of abuse cannot be ruled out outrightly, in the sense that some bees are inherently vexatious. From my own personal observation, working in the chambers, seeing bees, some bees, they are not well researched, and apart from that, some bees are just initiated just to keep some people on their toes. And in the course of doing that, we find that some members of parliament are really not serious in pushing certain bees to their logical conclusion. So to that extent, I would agree that some bees could be tools to abuse the legislative procedure. But if a member who initiated a bee and is sponsoring a bee on the floor, a bee that has clear intent to address a national or a community issue, and then it meets all the criteria for passage, then if along the line the bee suffers setback, we cannot say that it was abuse. I have not seen a scenario where a sponsor of a bee would collude with those who are against the bee to kill the bee. That I have not seen that. So it depends on the intent. It depends on whether the bee is being perceived as solving a problem, and then and it depends on the seriousness of the promoters of the bee. But the first question you asked earlier, whether a bee can be withdrawn, I want to tie this to my own response on that, to this very question. Yes, I agree with my sister there who said it can be withdrawn at any stage, just like any other bee. Technically, yes. But again, we have to find out whether the member who is sponsoring the bee is also the initiator of the bee. There must be a clear difference, because sometimes the sponsor of the bee may not be the initiator. So if the bill is being driven by external bodies like civil society, other stakeholders, I will not expect a member of parliament to arbitrarily come to the floor of the house and say, look, I'm withdrawing this bill, without having stakeholders consultation. So, but if the bill is coming from him alone, yes, he has that latitude to do that. So technically, by procedure, a bill can be withdrawn, but prudence demand that if you are not the initiator of that legislative idea, there has to be consultation before it gets to the point of withdrawal.
Okay, thank you very much, Ray. Caroline, do you have something to add to that? Okay, so let's hear from the audience, Marian, and then from Marian, we'll take that of Jacob, and then the gentleman there will take three. The panelists will address, and they will come back for the next set of questions.
Okay.
So,
Thank
Marilyn.
you. I have quite a number of questions, but I don't think I'll ask, or I'll send some to Senna. But for me, what bothers me most is that, as Honorable said, stakeholder engagements with Parliament have always been the expensive thing. CSOs have supported ministries upon ministries to develop bills. And somehow when it gets to the stages where they have to engage them, there's that difficulty. Now you see that with PMBs, which Ghana was part of, and I'm very proud that today we are talking about it so easy. You see that it looks like it's easier from this end. Now, the drafting office is helping with that aspect where we're having difficulty getting people to draft. As Honorable Mubarak said, from that stage, what happens? Because there's still that problem where after it's drafted, it doesn't move on. And then two, there's also for me the issue of somebody is promoting a particular bill. Let's say there's a sector ministry that was already handled, like the gender ministry. There's so many bills that's proposed that's not gone anywhere. And the cycles of Parliament just pass it by. So for me, if CSOs promote some bill that the gender ministry, for example, is delaying on, how do you address those conflicts so that we don't have a problem where government wants to do something and I don't know whether it's deliberately frustrated because there's always an excuse. It's at the cabinet stage, it's at this. But if it passes to PMB and it's going to go faster, civil society can easily do that and then get the thing passed. So I would like to see how we're coordinating those ends. Thank you.
Okay, Jacob, can we have that of Jacob and then the gentleman in the seats? Jacob.
Thank you, Gilbert, and thank you for the opportunity. The platform is quite great. My question was a bit aligned to that of the previous person who talked about the gap between what government may be planning to do, let's say ministry, and then private members decide to push something, let me say the same thing or similar. What happens? Why would the government initiated policy delay and then ours come in? But let me just, mine is a comment I heard as the buhaha around the LGBT plus, Q plus issue was going on. I think I heard something around PMBs cannot bring cost to government. I want to be clear on that, whether it's either initiating it or actually whatever the bill is shouldn't cost government. If that is so, I would also want to take experiences from Ray and then Caroline, if possible. My question actually is directed to Auntie Senna, if I may use the word.
Yeah, so the gentleman there, and then Senna will address the questions.
Yes,
and they will come out from that set of
thank
questions.
you very much. In the event where you get multiple bills from the private sector, so to speak, what is the dynamics like? Which of these bills is going to be approved? And what has been the experience? Because I know there are a lot of lobbying in ensuring that a bill is passed. So under this circumstance, how is the dynamics going to be? And what is also the regime or the application process? Is there a specific moment where it is solely a private member bill that is accepted so that there's no competition with the public or the government bills?
Okay, thank you very much. So now, Senna, you can address these ones and we'll go for another round of questions.
Okay, so on the issue of after drafting Marian, after drafting, the Article 106 requirement kicks in. It is gazetted. Again, let me just share the experience. So we draft the bills, we get copies, I mean, the member is satisfied, we sign, he signs off, and then in some cases, the member even submits him or herself to the clerk. and then the requirements follow. I'm cautious about the proposed procedures because as of today, the discussion is that we may have a committee so that when it is submitted, the committee also confirms that it passes the legislative competence test before it is programmed for introduction. The committee is yet to be formed. So as of today, it's submitted to the clerk. Gazette publication goes on. When it's matured, it's introduced. Then on the issue of clash of bills, where we probably have the executive also pursuing the same thing. I'll share the experience with the Office of Special Prosecutor Amendment Bill, for example. The object for both, I mean, the government is also working towards that. And I'm aware since 2017 thereabout. So the content are the same. As of today, ours or the private members is ready. So that has been gazetted. Probably when we get to, and it's been introduced and referred. So probably when we get to the committee stage, that discussion will come up and the members will, the government and the member will decide the way forward. You know. Then on the discussion of Article 108, as of today, the agreed position is that Article 108 relates to money bills, so that if the legislation is not intended to impose a tax or a levy or have the specific purposes as indicated in 108, it is good to go. So the cost probably involved in probably paying the draft person, the cost involved in gazette publication and all of that is not considered as the intendment of Article 108. Yeah. Of course, so far the ones we have drafted, we have been careful not to establish an authority, a commission, you know, which will probably raise the discussion, because the question will be who pays those officials and all of that. But the discussion, as agreed at various meetings, and most importantly, the 16th July motion was to the effect that Article 108 applies to money bills. The most important thing too is that in 108, the provision is clear that unless in the opinion of the person presiding, if I may just read 108. Okay, so Article 108, Parliament shall not, unless the bill is introduced or the motion is introduced by or on behalf of the President, A, proceed upon a bill, including an amendment to a bill that in the opinion of the person presiding makes provision for any of the following. 1, the imposition of taxation or the alteration of taxation otherwise than by reduction. 2, the imposition of a charge on the consolidated fund or other public funds of Ghana, or the alteration of any such charge otherwise than by reduction. Or 3, the payment, issue or withdrawal from the consolidated fund or other public funds of Ghana of any monies not charged on the consolidated fund or any increase in the amount of that payment, issue or withdrawal. And 4, the composition or remission of any debt due to the government of Ghana. So I've read 108A, which relates to bills. So the understanding is that this is referring to money bills or financial bills, not any other bill. Of course, every bill will have some cost implication, but the 108 intention was for money bills. I think there was also a question on time. Yeah, I think I've answered that, where the government and a private member are doing the same subject. I shared the experience with the OSP. That's how today the OSP has been gazetted. Government is here to submit it.
At the same time, it's all going to be passed. Is it that? Or there are specific bills that can go through within a particular year?
Well, there's rather the discussion. Again, I'm particular about the fact that the discussion is still, there are still proposals. They've not been adopted yet. But the discussion so far is that a member of parliament should be limited on the number of bills they can introduce. Yes. But if you look at the general legislative calendar, for even when we had only government-initiated legislation, we could have as many as 30 bills. Those are just programs. Assuming all those bills are ready, they will be introduced. And we by reason of maybe other responsibilities that Parliament is involved with, all of them will not pass. But there's no limit on the number of private members' bills that can be introduced at a time. The discussion rather is to put a limit on the number that a member can introduce.
I think that if I got your question or the sense of your question right, what you referred to was the bills from the private sector. I think what Senna sought to explain is that if a bill is emanating from an individual or outside of Parliament, which I take it to mean the private sector that you referred to, it has to be parented or sponsored by a member of Parliament. You see, so that needs to be made clear that while we can participate in the legislative process, the vehicle to do that is through a sitting member of Parliament. And that's why the Honorable Mubarak referred to a Minister of State who is a member of Parliament, and Senna said, if he's doing that in his capacity as a member of Parliament, then she didn't see anything wrong with it. So let's get that clear in our mind.
Yes, in addition, just a minute. In addition to what has been said, I just want to also quickly chip in something on the cost implication of private member bills. I have seen that one of the reasons why many or several private member bills failed was because of the cost implication to government. So if members propose bills that has huge budgetary implication on bureaucracy, there is a tendency for government not to assent to those bills, even if it is passed by Parliament. So that is something that I know for a fact, in many Parliament, because most government don't want to be overburdened by extra costs of running government. A bill that seeks to establish an agency, if the agency is established, is going to be run by people. Those people are going to be on payroll, and you are going to have a cost of maintaining the buildings and all of that. So government is always very reluctant to support legislative initiative that has huge budgetary implication on the bureaucracy. So I just wanted to be mindful of that, but that doesn't mean that those bills cannot come up, but members should be mindful that government is not always interested in what we expand the cost of governance.
Yeah, thank you very much, Ray, for your take on that particular matter too. So we are coming to the second round of questions. Second round, we have Clement, we have Sheila, and then Felix. So due to time, we are supposed to end this section. In fact, we are just a minute away from ending this section. So unfortunately, this is going to be the last round of questions. So if there is another person who wants to ask a question, then we add the person to this round. If not, after taking Clement, Sheila, and Felix, we'll continue with the last item, which is the closing remark by Sami Oben. Okay, so Clement.
Okay, thank you very much for the opportunity. First of all, I want to say that this is a very good opportunity and an eye-opener for us all, especially the media, since I'm coming from the media aspect. And I'm going to use this opportunity to actually appeal to Madam Kate to facilitate such a training program for the core, so that we'll be able to, yes, we'll bring you a proposal. So I'm serving notice so that when it gets there, you fast track it. Now, I want to find out from Madam Senna, all this that you have given to us, as I said, It's very educative and eye-opening. Is there any place that we can find these guidelines? Is there any particular place that these guidelines could be found? If we had not brought you here today, how would we have been able to follow this? Thank you.
Yes, Sheila.
Okay, thank you very much. My question goes to Madam Kate. Madam, please, when you were talking, you said we should engage the public affairs to know much about parliamentary proceedings and much about Parliament. Aside the media being the channel through which you communicate to the general public about happenings in Parliament, how does one approach the public affairs to know what goes on?
Okay, Felix, and then we'll take the last one from. Okay, since she's much closer to you, let her ask a question, and then before.
My question is to Senna. I would like to find out whether the drafting office limits itself to just couching the intent of the sponsor or initiator in appreciable language, or you are allowed to have an opinion on the subject. And where, if you are allowed to have an opinion, where your opinion clashes with or differs from what the initiators intend, how is that resolved?
Okay, so the last question by Felix, and then we are done with our question time. The technician, please check whether there is any question in the chat box.
Yeah, my question goes to either Kate or Senna. I want to find out if a member of parliament sponsor a bill within a meeting of parliament or the session of parliament, and unfortunately pass away, can the subsequent MP from the constituency take over the bill, or how do you handle that issue? Thank you.
Okay, thank you, Senna.
Okay, so Agnes, your question borders on issues of ethics. The sponsor is a client. My responsibility is to ensure that the draft sits well with existing constitutional and legislative framework. As to whether I like the policy or not, that question does not arise. That question does not arise. On the question of whether, what happens if a member passes away? Okay, I think rather there are clear provisions, or there's clarity on the fact that when the parliament is dissolved, the bill lapses. But if in that meeting or in that session, or in the life of that parliament, the bill is still alive, I think it will be an issue of discussion. There should be a sponsor who should be able to take it up, unless nobody else is interested. But once it's introduced, I guess you are talking at the stage where it's been introduced. So it's now a property of government, of parliament. I don't expect it to die because the sponsor has died.
If a member is unable to, so why, instead of saying a member dies, if a member is unable to, for whatever reason, be it their demise or their removal from parliament, or for whatever reason, is unable to, continue with sponsoring a particular bill, is there a provision for, resolving that?
I believe that will raise, or that's an opportunity for some discussion to take place, because the bill itself is, I believe, is different from the sponsor. So if the sponsor is not in a situation to continue promoting it, I don't expect it to die, but that would be a discussion I suggest for leadership to have. Yeah. In fact, I have always advised that there should be multiple sponsors. I have always advised that there should be multiple sponsors.
Okay, thank you. So that brings us to the end of, so
I think Sheila wanted to find out how to engage with the public affairs, but what you really want is how to engage with Parliament. And so the public affairs department is the first gate, to engaging with the various publics in the Parliament of Ghana. There are telephone numbers that you can reach us on. Our online sources are available. We also have physical presence. And all these are open to you, depending on which one is convenient for you, depending on geography, location, and all those things. We try to work long hours, and our telephone numbers are usually active for reasonable amounts of time during the day. And so it's quite easy to reach us. And there are some of you here who reach us at sometimes unreasonable hours, but Clement is laughing because he's guilty of that. But we try to be available. And usually some of the questions that you would ask are questions that would lead to us pointing you to technical people like, Senna is doing. So please engage us more. We would like to talk more to you and with you. And yeah, so that's how it is that we do it. And we have town hall meetings, we have person-to-person engagements, we have youth programs, we have programs with religious leaders and specific target groups aimed at demystifying Parliament. So we try to, as much as possible, engage with the citizenry, and we would like to hear from you. It'll be good to hear from you.
Thank you very much, Auntie Kate. So Sam, closing remarks by Sami Obin.
Thank you so very much, Gilbert. I had to do this on behalf of Dr. Odro, who is slated to close us on today's activities on behalf of the Board of Parliamentary Network Africa. I think that combining remarks from the first and second sessions, I am excited to note that it has been a very useful day. Of course, the project has already officially been commissioned, and we have taken a very good advantage to have a learning session, one of those learning sessions within the Ghana context on the private members bill bit. It's a very new gray area. I'm happy that, there were some amazing thoughts that were shared, by Senna in her presentation. Some of the things in there, I'm sure were very, very new to many, many of us, although we had even engaged with Parliament for some time. Of course, Director for Public Affairs, as always, lended her thoughts to that. And our colleagues who had joined with perspectives from other countries, had contributed very immensely towards the learning exercise that we had gone through. For us at PN Africa, we need to document some of these things, so that there could always be knowledge materials around these matters that can be useful for people going forward. And so we expect that this will generate into some policy briefs, on this subject of private members legislation, and we'll be following the process very much. And Gilbert had mentioned already in the presentation that we want to play a very integral role in non-state actors' participation in the whole private members bill legislation process as an organization. And our doors are always open to engage so far as that particular subject matter is concerned, while we also work closely with our friends in Parliament. So on that note, let me thank you all very, very much for taking time, both virtually and physically, to join us. And we are hopeful that going forward, you'll be making time to join us in subsequent activities, even as we learn and share together. Thank you so much.
So thank you very much, Sami Obin. So that brings us to the end of today's engagement. It's been a long one from morning up to now, and we are most grateful for all participants for staying throughout the two sections. And we have one or two amamre to do, so please don't go away. We have the snack, so kindly take some snack and then, but please let's have the group photograph first. Yes, that is very important. So let's take the group photograph now. So let's collapse this. Let's collapse this table so that we use the background. We want to use the background. Oh, okay, we'll just move the background to the other side. Take the group photograph. Let's have our snack, and then we do our mamre. Thank you very much, and thank you to our online audience.